participants to mute their microphones if it is not already muted by the organizers. At the very end, there will be the Q&A session. So please put your questions in the chat box at the bottom. I will try to go through each of them at the end of the session. We will have around 15 odd minutes for such Q&A. I have been asked by the organizers to say the following words, and I am very happy to say so, especially when I am one of the sponsors. I would like to acknowledge the contribution of all the sponsors whose generosity has made this webinar possible. Their logos can be seen on your screen. Now, that's the logo above my head and to my left and right. Now, and I've been asked to keep that screen on for 5 seconds so that everyone can sink in all the sponsors' name. Now, the topic of today is how mediation becomes developed within both the legal system and society, and what the practice of mediation has taught us, a European perspective. Now, I would just like to add a few words in that respect, because next week in Hong Kong, there will be a pilot scheme announced in the district court in Hong Kong, where mediation will sort of becomes compulsory. Now, I am going to ask a few questions at the very end myself to the distinguished panel of speakers here. Obviously, mediation, like in everywhere, in Hong Kong and everywhere, is now an accepted part of the dispute resolution process for parties and their advisors in much of the world. But for many jurisdictions, this has been a relatively recent development. Okay, in Hong Kong, only this couple of years. Often only in other countries, like in other Asian countries, 30 to 40 years. The capsule will look at how mediation entered the mainstream in Western Europe. Obviously, the panel of speakers are from Europe. Now, our distinguished speakers, okay, like Mr. Jonathan Lloyd-Jones, Mr. Nicholas Parra is from the UK, Mr. Claude Amar is from France, and Ms. Birgit Glasner is from Switzerland. And please pardon my pronunciation. They will talk from their experience as full-time mediators of some of the challenges they faced in encouraging the use of mediation in their own jurisdictions. In particular, early oppositions from the legal community and how this was overcome. In some jurisdictions, there is still quite a bit of opposition. How the judges went from being hostile to vigorous supporters. This is the situation in Hong Kong as well. The assumption that mediators had at the outset as to what would happen and what experience has shown has actually happened. How mediation has found a place in wider society, what conclusions might be drawn from their collective experience as to how greater use of mediation can be encouraged. So without further ado, I shall introduce the first speaker. As time is a premium, I shall give a brief introduction, as all the panelists have given me more than 1 page of CVs. So Claude Amar from France is our first speaker. He's a registered architect, a hotel developer, a real estate assets manager, and of course, a mediator. He was trained as an architect and has studied finance at INSEAD, Institute European, the Administration, the Affairs, and Negotiation at Harvard. He was trained as a mediator by Gary Friedman at the Center for Mediation in Law in San Francisco. Claude, a founding partner of Mediation and Resolution, is an IMI as well as IFCM and SIMI, certified mediator, and has accredited by several international mediation centers, including ICC in France, IAM in Paris, HKIC Hong Kong, SIMC in Singapore, GIMC in Japan, BIAMC in Indonesia, and ICM in Santa Monica. Claude is also a member of the Board of Governors and a distinguished fellow of the IAM, International Academy of Mediators, the president of the Académie de la Médiation, and IMI, International Mediation Institute Standards Commission member, the president of IFCM, and a member of the working group of the ICC International Mediation Competition, where the Hong Kong International Mediation Competition will be held, just to do some advertisement, between the 11th and the 14th. So without further ado, I shall pass the stage to Claude, or I shall pass the mic to Claude. Thank you, Claude, it's all yours.
Thank you very much, Ronald. Thank you, Jody. Good evening, everyone. I'm very happy to be with you, although I sit in Paris and cannot enjoy the vibrant energy of Hong Kong. Let me tell you a little bit how mediation has developed in France. Ad hoc mediation was first introduced in France in the early 80s in spontaneous parenting support associations. In the so-called ad hoc mediation approach, mediation is freely and spontaneously chosen by the parties who themselves make the choice of the third-party mediator. The first associations defending the benefits of mediation were created in the 80s and 90s. Court-ordered mediation was established in France by the law in February 95 and implemented in July 96 in the Code of Civil Proceedings. This form of mediation is part of the legal proceeding. It shall be ordered by the judge, subject to the acceptance of the parties. Then the judge appoints and mandates the mediator. It should be noted that the judge is in a position of very strong incentive. In the event of acceptance in the course of the proceedings, the judge shall make an order for mediation. The initial duration of the mediation may not exceed 3 months. This assignment, however, may be renewed once for the same duration at the request of the mediator, the judge, and/or the parties or their lawyers. In April 2008, the European Parliament adopted a directive on certain aspects of civil and commercial mediation. The purpose of the directive was to facilitate access to alternative dispute resolution mechanisms by encouraging the use of mediation. Mediation was defined as a structured process in which 2 or more parties to a dispute voluntarily attempt to reach an agreement on the resolution of the dispute with the assistance of a mediator. This process could be initiated by the parties, suggested or ordered by a court, or prescribed by the law of a member state. In August 2015 in France, the trend towards a legal framework was confirmed. This order introduced consumer mediation, which was extended to most economic sectors. At this point, mediation is increasingly legally regulated, including under its ad hoc aspect. Now, in fact, how did mediation take off? In 2013, a judge who used to teach mediation to students judges was appointed in a real estate chamber of the Paris court and gathered a panel of 8 mediators. Within a few months, she had ordered approximately 1,000 mediations, which did draw some adversity from her fellow judges. She was then summoned by the Paris court's president, to whom she showed her chamber's mediation statistic. Parties had met in 97% of the cases. Agreement were reached in 74% of the cases. Agreement was reached within less than 3 months between the first meeting and the execution of the agreement, and the average cost of mediation was below 2,000 euros. This was the trigger for mediation in France. it started to spread within all courts, including the Paris Court of Appeal, where this judge was later appointed. Today, all French courts order mediation, generally very early in the legal proceedings. Inevitably, the question of the mediator's professionalism was raised, as there is no official mediators roster in France. Quality assurance became of the utmost importance, as we believe quality is the best way to promote mediation. An attempt to introduce mediator certification was made using the IAM certification process, especially with the various courts of appeal, unfortunately with a limited success. The Ministry of Justice then decided to implement the same system for mediators as what was in place for the experts body, in other words, to maintain an official list of mediators with each court of appeal. The problem created by such list is that there is no quality control. And for example, the Paris court has more than 800 mediators on its list, some of whom have conducted 1,000 mediations, others have conducted 2. Besides, France being a free justice country, the court-ordered mediation rates make France's best mediators somewhat reluctant. Which leads me to point out a significant difference between UK and France, for example, where the ratio between court-ordered mediation and ad hoc mediations is completely symmetrical. In France, there are approximately 90 court-ordered mediations for 10 ad hoc mediation. The French Bar Association is working in that direction, but it will take time. I'm sure my British fellows are going to address this today. Other points of interest are the introduction of other methods of dispute prevention and resolution, such as deal mediation, which is more often called project mediation in France. Deal mediation is when a mediation is used to help build the partnership in order to make sure all parties' interests are aligned. Arb med arb, arbitration, mediation, arbitration. Surprisingly, nowadays, several arbitrator panels have suggested the parties to put the arbitration procedure on pause for a few weeks and attend a mediation session in order to try to find a global or partial solution before resuming or stopping the arbitration procedure. Sophisticated mediators have added baseball arbitration, also known as last offer, in their toolbox and pull it out whenever there's a deadlock, rather successfully. In this case, the mediator asks both parties to submit their last offer, the mediator's role being to choose the most adequate one without making any adjustment to it. The French Academy of Mediation has 3 development tools which it promotes actively. First, a mediation presentation, which is carried out freely within various companies, allowing them to use the presentation and make it theirs for internal use. The Academy has also launched the company's pledge in favor of mediation, which has already been signed by 80 of the major French companies, as well as the lawyer's pledge, which has already been signed by 600 law firms in France. In short, there is still a long way to go, but the potential is very favorable. Thank you very much.
Thank you, Claude. Frankly speaking, I do have a couple of questions, which I'm going to save it right at the end. Now, we have heard from the representative from France. Now, moving on to our next speaker, and she's from Switzerland. Birgit, let me introduce you to the audience. I'm only going to read the last page of your 3-page CVs. Practicing dispute prevention and resolution on a full-time basis, a lawyer. Birgit is a partner at Altenburger, Switzerland, specializing in international issues such as business, commercial, banking and finance, employment, IP, construction, and cross-border inheritance and family laws. Formerly Deputy Conciliation Judge at the Geneva Court, besides her activities as attorney at law, she is acting as mediator as well as assisting parties in mediation since 1997. In the same year, she co-founded the Swiss Chamber of Commercial Mediation, a distinguished fellow of the International Academy of Mediators and a member of the European Advisory Board of CPR-ADR. She is a sworn mediator at various courts in Switzerland and is accredited, listed with various institutions such as the ICC, SCAI, WIPO, INSO, TAS, as in CAS, Court of Arbitration for Sports. She also acts as external mediator for the World Trade Organization since 2016, as well as for various banks, companies, and other organizations. Birgit implemented alternative dispute resolution at the Geneva Bar, while setting up the first ADR commission in 2012, dealing with arbitration, mediation, collaborative law, and dispute boards. One of her favorite activities in the field is teaching mediation, such as at the MIDS Master in International Dispute Settlements, Graduate Institute of HEI Geneva, as well as the Universities of Freiburg and Geneva, as well as previously in Torino and Hamburg. She is rather talented in her languages. She speaks fluent French, German, and English. And I don't quite understand what she means by some broken Spanish and Italian. Birgit, the microphone is yours.
Thank you. Thank you very much, Ronald. I'm very privileged to take part in this interesting panel today, and I would like to thank very much the organizers and the sponsors to be here and to be able to share with my distinguished, not only colleagues, but friends, and also with all of you around the world. So let me talk a bit about Switzerland, evolution of mediation in Switzerland, and how and why it started. You have to understand that the concept of ADR is quite old in the northern part of Europe, and it covers the terms of mediator, conciliator, and ombudsman. Ombudsman is a word which in fact was found in Sweden in the 18th century when King Carl XII designated a mediator to protect the rights of the citizens. So it started really there. And then you have various Scandinavian countries which followed, Finland first, and then after World War II, you had Norway, Denmark, and Germany and other countries also outside Europe followed. So it's pretty old. And in Switzerland, even before, in the 15th century already, mediation acquired its important status and recognition through the intervention of a former judge and advisor of one of the founding cantons of Switzerland. The person was called Mr. Nicolas de Flue, and he became an hermit at some point in time. His love for peace and his mediation art made him conciliate lots of things in Switzerland, but notably the war between the agricultural cantons and the cities. So he was one of the principal unifiers of Switzerland. And this is why also we have this perception that mediation has a lot of standing, and we really believe in that. Afterwards, still in history, the Mediation Act in 1803, promulgated by Napoleon Bonaparte, who claimed himself being a mediator, ended the constitutional conflict between the Unitaries and the Federalists in the Republic Helvetica. Meaning you see that Switzerland has a long-standing for mediation, has a long-standing also for neutrality, of course, and independence. And it goes without saying that the international organizations like UN, Red Cross, WTO, and so on, all of them use mediation and other alternative dispute resolution processes. And this is really and they have their seats in Switzerland, and this is really what it is about. Now coming to Switzerland, you have to understand that we had various cantonal legislations until in the 1990s, where some of the cantons were using civil and criminal mediation, and Geneva was a precursor in this field. We had lots of family mediations already and criminal restorative justice. Things changed in 2011, where finally we had a unique code of civil proceedings, which recognized and enhanced mediation as an additional instrument to resolve conflicts at disposal of the people, the advocates, lawyers, and the judges. And I'm just going to read you a little passage from the Swiss Federal Council's message accompanying the new code. It says, the amicable regulation of conflicts has priority, so priority over the judiciary, because transactional solutions are longer lasting and more economic, less expensive, because they can take into account features that a court cannot take into account. So this statement really made mediation grow in Switzerland, because suddenly we had the recognition of the Swiss Federal Council. It changed its image, and it lost a bit its quote unquote therapeutical perception. Before we had a bit the issue about mediation, meditation, and people were smiling when thinking about mediation. So civil judges became more and more the prescribers of mediation, even though, to the contrary of what you have heard from Claude in France, we have no mandatory mediation, at least not on the civil side in Switzerland. We have certain judges in matters which involve children, which can not force, but really ask people to go to mediation, whereby also mediation is going to be free of charge for a couple of sessions. Otherwise, we don't have court-ordered mediation on the civil side. Instead, on the criminal side, on criminal justice, notably in criminal justice for minors, we have the possibility to have court-ordered mediations with a very good success rate of more than 77%. So the last domain where mediation has been enacted in Switzerland is the new Finance Act, which is in force since 2020, where mediation organisms have been set up in order to resolve conflicts between a final service provider and its customers. So, in fact, usually in Switzerland, we have conventional mediation in civil and commercial matters, whether ad hoc or institutional, where sometimes the court are involved for what we call the homologation of the agreement in order for them to become judgments and be enforced as such. So it means that a court would suggest parties to go to mediation. If the mediation succeeds and there is an agreement, then the court would homologate that agreement and would become a judgment and would be enforceable as such. We have to understand also that Switzerland has an excellent way to conciliate disputes, because we have judiciary conciliation. I was a former judge in that field, where we have excellent statistics too, with approximately 66% of cases being solved at the issue of this conciliation. So it's a kind of competition with mediation, and it works very well at the court. Even though you can, if you ask for conciliation, you can also ask not for conciliation as such, but having conciliation be replaced by a mediation performed, of course, by an accredited mediator. In Switzerland today, we have more and more mediations running, and we have also more and more understanding with the running of hybrids. Like Claude said before, I mean, AMA, mediation arbitration, has become more and more popular. And of course, also last offers and other hybrids, which we have experimented. I mean, I have experimented myself, which are a very good finally solution or an answer to international disputes. SCI, which is the Swiss Chamber Arbitration Institution, which also provides for mediation, has adapted its rule accordingly and now provides also for AMA and this kind of hybrids. Mediators are usually accredited by institutions, and in some of the cantons, they are even taking an oath. So I took an oath in front of the government, or I can take an oath also in front of a court. And the oath is very similar to lawyers, and we have a supervisory authority which is going to decide if we do something which is not ethical and not in the rules. There is excellent education also for the lawyers at the start of their career, where they are taught mediation and they can continue their education with various kind of education programs at the MIDS, as we said before, Master for International Dispute Settlements, or different CAS and DAS at the universities in Switzerland. So where are we now compared to where I would think we should be? I must say I had expected that it would be even more relied by the courts, who are, at least in Switzerland, and I'm sure it's more or less the same in the world, completely overwhelmed. But they're still not very much in understanding what mediation is about. So there are there's laws in enactment today in order to a bit force the judges to take some education in this regard. Even though, I mean, the image has changed, the mediators have a standing, we understand better its meaning, and we get more and more international conventional mediations. Also with Asian parties, lots of international mediations are happening in Switzerland, also because of its understanding, the understanding of the world, of the role of Switzerland as such, as a neutral place to be. So we are slowly getting there, but this is typically Swiss. Swiss is slow because we all have and all need consensus. So how can we enhance that? I mean, and I joined Claude in saying that we need to be better mediators, even more better mediators. We need quality. There are lots of education programs, and we need also a very good centralized association of mediators who are taking care of our interests. We are getting there, and slowly by slowly, I think this is going to be even better in the future. We need to, at some point in time, sign the Singapore Convention. Switzerland did not for the time being. And to my understanding, now that it is running in the world, I think Switzerland wants to become what we said about Singapore. I mean, Singapore at some point in time claimed to wanting to be the Switzerland of Asia. We want to be the Singapore of Europe. Let's have this kind of dreams. Accreditation of mediators in Switzerland, usually you need 120 to 200 hours of education in order to be accredited in one of the institutions, and to, in case you want that, to take that oath, in fact, in front of the government. To me, the mediation in Switzerland is still respecting the core principles, meaning, of course, confidentiality, neutrality, and so on. So we are still there where we want to be. We're not too dogmatic. We are quite efficient, very efficient, I think even, and we have a lot of stance, I mean, and of standing about ethical rules. We really want to be ethical. Of course, we have to be very careful with all these alternatives like hybrids, which need to be included today in the dispute resolution picture, meaning we really, as mediators, as arbitrators, as neutrals in hybrid systems, we need to be very clear and check with the parties that they really understand what they are doing in order to avoid pitfalls, like finally agreements changed into arbitration sentences not being recognized in some of the countries because of the way it has been performed, and of course under the New York Convention. Last but not least, I think it's important, we have almost no cases of liability of mediators in front of the courts, meaning that usually mediation, when it works, and it works, as we know, in Switzerland, like in the rest of the world, in 80% of the cases, you usually reach an agreement, and usually we don't have any challenges of these agreements afterwards, and they're enforced. So this is what I wanted to say, and I'm looking forward to participating in the questions and answers afterwards. Thank you.
Thank you, Birgit. Once again, I have written a number of questions down myself. So I hope we leave enough Q&A time for the participants and in particular myself. Now, we have heard from two civil jurisdictions, France and Switzerland. Now, we are moving on to the common law jurisdiction. Our next speaker is Mr. Jonathan Lloyd-Jones from the UK. He's a commercial mediator with Independent Mediators Limited. Jonathan has been a commercial mediator since 1991. He qualified as a solicitor in England in 1979, very well qualified, and has worked in London and Oxford. He was the chairman of his legal practice for about 12 years before becoming a full-time commercial mediator in 2012. He is ranked in the top tier of mediators in the UK. His practice is widely ranging, but with a particular emphasis on professional negligence claims and construction disputes. He is a distinguished fellow of the International Academy of Mediators and accredited by the International Mediation Institute. He also lectures both in the UK and elsewhere on mediation topics, including Hong Kong, of course. So welcome, Jonathan. The floor is yours.
Thank you very much, Ronald, and good evening to everyone. Thank you for giving us this opportunity to talk to you about our experience of mediation. As Ronald has said, I became a mediator about 30 years ago in England, and whilst mediation is now an accepted part of the dispute resolution landscape in England and Wales, and indeed strongly encouraged by the courts and widely used by lawyers, it wasn't always like this. And I thought I'd just spend a few moments looking at what the issues were when mediation was being developed in the UK, and how these were overcome. At least this is my perception as someone who was involved from the early days in the UK. There were a number of problems. First of all, the lawyers were suspicious. It was new and untried, this process. It was different. Lawyers are conservative people. They don't like change, in my experience, and they were suspicious of this new concept, really because they weren't familiar with it. Some thought it could be a sign of weakness, a reluctance to go to trial, and it might lead to lower fees as well. No trial sometimes meant fewer fees. ADR equaled an alarming drop in revenue. And that was how the lawyers saw it sometimes. I think the judges also were not sure about it. They thought, well, it's not true justice because there's no trial. The evidence hasn't been heard and tested. Settling cases by consent in private could prevent precedents being set and discussed. It was taking their work. But the public, they really knew little about it. It wasn't a word generally associated with lawyers or the settlement of disputes. Going to court was what settled disputes, not friendly bargaining. And so there was little understanding of what commercial mediation might involve. So, although it's fair to say that from about 1990 onwards, mediation started to be used as a method of keeping disputes out of court, it was quite a rare beast. In my experience, only the London court dealing with construction cases was actively encouraging mediation in the early 1990s. And it's fair to say that the number of full-time commercial mediators in the UK by 1995 was probably less than 10, although there were a growing number who were mediating as part of a wider professional practice. and actual mediations, as opposed to seminars and conferences on the subject, were few and far between. However, at that time, as Birgit has also mentioned for Switzerland, the courts had two major problems that they needed to address. The civil justice system was seriously overloaded, and there were long delays in getting to court and to trial. Furthermore, taking a case to trial was very expensive, and in many cases, the only people who could afford it were either the very wealthy or corporations who could offset the legal costs against tax. So whilst it was true to say that English justice was very good, it was also slow and costly. Now, it was decided that a way to address these issues was a comprehensive review of court processes and procedures. And so Lord Woolf and his committee published in about 1998 a wide-ranging revision of the rules of court called the Civil Procedure Rules. And there were two key objectives in those rules. One was the desire to speed up cases, and the other was to reduce the cost of litigation. The rules had what was called the overriding objective. And this was something that all those involved in both the administration of the law and the delivery of justice had to comply with. This was to deal with each case in a way that was, first of all, just, but just as important, in a way that was proportionate to the sum or issue in dispute. That led to a much greater active case management by judges and court staff, which meant that rather than allowing the law firms and the lawyers to dictate the pace at which cases were tried, it was the courts themselves who now sought to ensure that cases progressed promptly and without delay. And indeed, the CPR, as it was called, has a specific provision requiring judges and lawyers to consider and encourage ADR and mediation. And there was a further aspect of these rules, which were the pre-action protocols, which required parties, before they issue proceedings, to set out clearly what their claim was, how it was founded in law, what the main bits of evidence were, and what the losses were that they were claiming. And that gave the other side a chance to respond by saying whether they accepted the claim or defended it, why they defended it, and what they were going to rely on. And these pre-action protocols also expressly encouraged the use of mediation. But there was a problem. And the problem was that the lawyers weren't using it. The rules were all there, they'd all been set out, and they were very good. And the problem was compounded because the public, as I mentioned, knew little about how mediation worked. If a member of the public had a dispute, they went to a lawyer and they took the lawyer's advice. And of course, the lawyer's advice would tend to be based on what the lawyer knew best, what they knew from their own experience, which was of trials rather than mediation, because they simply had little experience in that. So the courts decided they had to take some steps to try and encourage the use of mediation. And the first thing they did was, through a case involving a public body, was to criticize the lawyers publicly for failing to go to mediation and bringing the case to court when it should have gone to mediation. And sadly, that of itself didn't have a very significant effect, although it did achieve quite a lot of prominence. The case that made the difference, and being a common law country, it was a decision of the courts, was a case called Dunnett and Railtrack in 2002. Now, Mrs. Dunnett had sued Railtrack, and Railtrack is the organization that runs the railways in England. She'd sued them for leaving a gate open, which had led to 3 of her horses straying onto the railway and being killed. So Mrs. Dunnett, she lost her case before the trial judge and decided to appeal. She lost in the Court of Appeal on technical grounds. Now, in England, if you lose, you generally expect to have to pay the winner's costs, something like 60 to 80% of those costs. But in this case, the Court of Appeal had said, before it came to them, that they ought to try mediation. Railtrack had said, no, we're not going to do mediation because we're going to win. And they did win. But the court said, because you didn't go to mediation, even though you've won, you're not going to get your costs. The court said this wasn't a case about money, but about responsibility. And all Mrs. Dunnett really wanted was an apology. Now, the courts were talking language the lawyers understood. They were talking bills and costs. And the clients also now understood that mediation was something they had to pay attention to. To win your case, but not to get an order for costs, certainly sharpened the minds of the litigators and changed the advice they gave on mediation. And so from 2002 onwards, mediation started to become much more widely used. And there've been a succession of cases since then in which the courts have strongly encouraged the use of mediation. And lawyers have now become much more sophisticated users. There was an important case called Halsey and Milton Keynes, where the court set out those relatively rare occasions when it's inappropriate to use mediation. And I think it's fair to say that today, 90 to 95% of cases that are heading toward trial will go through a mediation or an ADR process. What perhaps is slightly different in England and Wales from the civil jurisdiction systems on the continent is that it's very rare that the judges will order mediation. They will certainly stay the cases to enable the parties to attempt mediation. And also the parties very often have to report back on whether or not mediation has been successful. But the courts very rarely, and I'm not sure that they actually have the power to compel parties to mediate. But notwithstanding that, mediation is very widely used. And I think there are a couple of reasons why it is so widely used now, as opposed to when I started mediating back in the early 1990s. I think the first is that it has become much more accepted that not only do the practicing lawyers know about it, but a lot of the newer generation of lawyers coming through law school and through their training contracts are well aware of this and are not nearly so fearful, to use that word, of using mediation. I think the other factor that's important is that as a result of case law, it looks as though it's likely that any lawyer who refuses to or fails to advise his client properly about the benefits of mediation and going to ADR runs the risk of being sued for negligence. And whilst there aren't many cases at the moment in relation to that, it's definitely, I think, a factor in a number of lawyers' minds. And so I think there's plenty more that we can learn from the other systems, but speaking personally as someone who was involved in seeing mediation develop from its infancy in England and Wales to where it is today, it's been very gratifying to see how much it's become embedded into our legal and litigation landscape, and indeed how sophisticated and skilled lawyers are these days in using it. Thank you very much.
Thank you, Jonathan. You are in a territory which I am more familiar with because in Hong Kong, it's the common law system, the Lord Wolf, the civil reforms procedures are reflected in the old Hong Kong civil law procedures as well. So I have also a number of questions which I want to ask you later on, because as I said, Hong Kong will be reinventing the rules next week, especially in the pilot scheme in the district court. Now, last but definitely not the least, our last speaker is Mr. Nicholas Bryan. Now, Nicholas is one of Britain's most experienced commercial mediators and one of the pioneers of mediation in Europe. For the last 25 years, he has been continuously recommended as a mediator and ranked in the highest categories in the legal directories. He's noted for his commercial approach, His skills in analyzing and resolving complex disputes and his ability to relate effectively with parties, one of the traits of a mediator. Nicholas conducted his first mediation in 1986 and has mediated disputes in Britain, the USA, Europe, the Middle East, and Far East regularly since 1990s. This has included more recently many mediations conducted online, which is a trend now, I would say. He has been appointed in over 1,400 mediations. He was involved with the foundation of the Center for Effective Dispute Resolution, the CEDR, in London and in the late 1980s. He was a founding member of CEDR's training for faculty from 1991 and a non-executive director of CEDR from 1995 to 1998. He is also a member of the mediation panels of the Court of Appeal, the LCIA, the London Court of International Arbitration, and the Chartered Institute of Arbitrators. In 2006, with Michael Kalipetis QC, he co-founded the group known as Independent Mediators, which has grown to become Britain's most respected set of commercial mediators. He was admitted as a distinguished fellow of the International Academy of Mediators in 2000. And he is also from Great Britain. So over to you, Nick.
Thank you very much, Ronald. Good evening, everyone, from a slightly subdued London. As you have probably heard the news, the risk rate in London was upgraded about 10 days ago, and as a result, everyone feeling a little bit more glum than we have been over the summer. I was going to talk to you not about the development of mediation in Europe or in the English jurisdiction. Jonathan, my colleague, has already gone through that. I wanted to talk to you about what I thought we have learned over the years. Jonathan referred to having been at the infancy of mediation in England. My experience goes back a little bit further, and I can actually claim, I think, to have been at the gestation of mediation in England. My first involvement was in 1986, and there was nothing here at all in the UK, no interest at all. And so I have, over the years, have been one of those who in the very early days, in the late 80s, was on panels, was a frequent speaker and a lecturer, usually speaking to very skeptical audiences about what I and the other pioneers thought was the benefit of the process. We spoke, as I recall, with enormous confidence, with an almost charismatic conviction that this process was going to be extremely effective. No one ever, thank God, questioned us on why we were so certain about this, because I will now confess to you openly that, in fact, we had absolutely no evidence at all to back up our assertions. It was genuinely by way of a belief in the potential value of the process. Some of us, maybe about in single figures, 8 or 9, had actually taken part in a mediation. And in the late 80s, 2 of us, I was the other one, had actually sat as mediator. And it was so on that very, very limited level of experience, we felt able to assert what we thought would be the benefits of the process. And what I thought it might be useful to do is to look back over the 35 years, or the near 35 years since that first mediation, to see whether what we thought was going to happen has happened, how we thought things might develop, what we got right, what we didn't get right, and what has turned out in an unexpected format. The first lesson, and Birgit has already alluded to it, is the first great difficulty was to remind people there's a difference between mediation and meditation. The second difficulty was to remind them there's a difference between mediation and arbitration. And for years, I've been known as an arbitrator and not as a mediator. The third difficulty was to get over. We very quickly realized that what we were actually doing was not introducing something new into the English system. We were reintroducing something into the English system. And we look back over English legal history, and actually mediation has been there on the fringes for centuries. And for reasons we don't really understand, died out in the middle of the 19th century. So what we're actually doing is bringing something back. The concept of ADR, the alternative dispute resolution label that we used at the time, was, I think, something new. We were talking about introducing it so that it would be part of the legal system. There would be a body, hopefully a profession of recognized capable mediators, and people would resort to it regularly rather than on a sort of ad hoc basis being caught up in a dispute and looking around desperately to try and find someone. There would be established procedures and so on that people could follow. So that concept was new. But mediation, we very quickly realized, was as old as civilization itself. And people have been turning to others when caught up in a dispute and saying to them, you're outside the dispute, would you help us find a way through? And people have been doing that for thousands of years. So nothing new in the process at all. The other thing I think we have learned over the years is, and not to our surprise, the principles of mediation, subject to a few subtle variants within different cultures, but the essential characteristics of mediation, the principles of the process, are the same, we think, universally. We forecast for it all manner of benefits. We went out saying it will lead to a shift in style in litigation. It may lead to a shift in outcome. People will not be bound only by the outcomes of court. There will be huge savings of costs. There'll be huge savings of time. There'll be enormous flexibility, privacy, the ability for inventiveness. It may be better solutions. Overall, we started to identify qualities like certainty and finality as potentially commodities of greater value to parties than necessarily getting an outcome in their favor. Now, every single one of those was put forward on the basis of a belief that that's what this process would deliver. What has 35 years experience shown? And the answer is that if anything, not only those benefits attained, but the level at which we thought they would be attained has been hugely exceeded. Savings of time have been achieved on a very large scale. The levels of savings of costs, I have to say, it's my constant experience in mediation, that most matters that come forward for mediation come forward far later in the process than they actually need to. And that a lot more costs have been expended than were truly needed to get to the position where mediation was possible. And it is still true that one of the handful of 2 or 3 causes that bring mediations to a halt and prevent them settling, one of them is that the costs are too big to be enable an accommodation. There's just too much at stake in the costs. We got, as Jonathan has outlined to you, we ran into a lot of objections to the nature of the process. You will know that it's traditional in Western culture at Christmas to eat turkey. We were all accused, of suggesting to lawyers that they behave in a way that was like turkeys voting for an early Christmas. And it's absolutely true what Jonathan said, that a lot of people objected to the potential impact on their cash flow. But people said to us, well, adjourning for mediation will cause delay, and the costs, and what if you don't get a result, then all the costs that have gone into it will be wasted. And people will abuse the process. They will use it for fishing, for information, from the other side. They want to cross-examine the other side's parties in advance of the hearing. There will be no genuine engagement. People will use it simply, they will filibuster, use an American term. They will use it just to waste time. And Jonathan mentioned this, and this has been mentioned by a number of people who objected to the concept, including a very famous academic here who thought it damaged the British Constitution, that it would affect a number of cases coming through to trial and thereby creating important precedents. My answer to that was to always quote the very first time I had a major case at Lloyd's, and I bounced in to see the chief underwriter of the syndicate I was acting for, and got very excited in front of him about how if we ran this case, it would be a whole new area of law. It would touch on aspects of the law that had never been dealt with before, and very excited, and fill a gap in the textbooks, I said, and then stopped. And he said, he leant across the table to me and said, "Well, young Nicholas," it was an awful long time ago, "well, young Nicholas, how much do you feel I should pay to fill this gap in your textbooks?" And I have never forgotten that lesson. And it is, I believe, the inalienable right of anybody in the country to refuse to spend money simply to fill up the textbooks with new law. There's no such obligation. People are entitled to settle their cases, and they always have been. What mediation does is help them in the situations where normal face-to-face negotiations have not succeeded. What else were the objections? Well, people said it was an abuse. There were human rights issues. You were depriving people of their right of trial. The answer to that was, no, you're not. We're just seeing if you can sort it out without needing to go to trial. There were all sorts of objections to the scope of mediation, where it would be suitable. My memory is being told, oh, well, it'll work in smaller cases. But there are all sorts of areas of the law, I was told, where it wouldn't be suitable at all. And it always turned out to be that the person telling me that was a specialist in the area of law that he'd just identified as unsuited to mediation. How has that turned out? Well, we thought there were one or two areas. We thought, I mean, even now you can't really get an injunction through mediation. So in terms of procedure, we can't possibly do that. But there's absolutely no other area of law where mediation hasn't proved itself in the end to be very effective. So there's absolutely nothing about the nature of a case that takes it outside the scope, nor is there anything about size. I mean, if anything, the smaller cases, and other mediators may have similar experiences, the smaller the case, the harder it is to settle. I've spent days trying to settle a claim for £25,000, and I managed to settle a claim for €5.5 billion. That's 5,500 million euro in 3 days. So it's nothing to do with the size. The other thing that people got very concerned about was the ethics. Mediators need to be regulated, and there are all these difficult ethical issues, particularly to do with justice, and the mediation would not deliver just results. Occasionally, that's true. Occasionally, people settle for something that isn't awfully fair, objectively. Most of the time, it settles at something that both sides are reconciled to. And this is a standard of slightly cynical saying amongst mediators that if all the parties are equally unhappy with the outcome, then perhaps it's probably the right outcome. But the dilemmas and ethics and theoretical issues in practice hardly ever come up. It is an astonishingly simple and straightforward process. We discovered that it needed terribly little organization. I have once been invited to shortly before 12 o'clock. What was I doing at 2? And I started a mediation blind, and we got to a perfectly decent result with no preparation at all. We found that it needed a very different form of dialogue. We were right about that. And as Jonathan has pointed out, the legal profession in the UK has gone through a revolutionary change, particularly over the last 20 years. People now are well aware of the benefits of mediation, and they're well aware of what makes mediation prosper. Did we get anything wrong? This is a very touchy subject, but the one thing I know we did get wrong is that we thought at the outset the men would be terrible at it. Men are sort of universally known for being judgmental, impatient, jumping to conclusions, and constantly guilty of mansplaining. And to our absolute amazement, actually men turned out to be really rather good at it. So that was one thing that we definitely got wrong. We've ended up, as Jonathan has outlined to you, with mediation deeply embedded now into the legal system. It is now impressing its way slowly into the system of arbitration. It's widely used as an annex to the court's work or as an alternative, but it's spread outside the dispute resolution system. It's widely used by the government, by local governments, by national organizations for the resolution of all manner of difficult problems. There's mediation now in almost universally used in divorce cases. There's widespread use of mediation in the community. There is a whole areas of activity known as restorative justice, which is an offshoot of mediation. Sometimes matters of the greatest sensitivity are given to mediators to handle, and the matters are concluded and resolved. One from time to time sees headlines on the TV news at night that such and such has been resolved, and being a mediator in the business and knowing around, I know exactly who was behind that and how it was resolved. Indeed, it was thanks to a mediator that we ended up with a coalition government in this country in 2010. We managed to create a coalition government, and I think it was 5 days. I think it took Belgium about 5 years. That's not wishing to be any way rude to Belgium. But that was the mediation process used within the behind the scenes and in preparation for what was foreseen for some months as a likely outcome of the 2010 election. You may have whatever view you may like about the effectiveness of the coalition government, but the very smooth transition to power was one that was very quietly and unobtrusively from behind the scenes mediated. And has it proved effective? Whenever I'm asked that question, I have one answer. I say to people, I've been at it for 35 years nearly. I keep 3 notional files. One is of all the messages I get from parties saying, I'm really glad I settled. Variations on that. That file is full to bulging. It's actually a notional file, as you probably picked up. It's not a literal file. There's a much smaller file, which is from the people who contacted me afterwards and said, I really wish I had settled. That, thankfully, is kept very small. But a lot of people have not settled and gone on and bitterly regretted it. The third file is for all the people who got in touch with me saying, we really wish we hadn't settled. And that file remains, after 34.5 years as a mediator, totally empty. Thank you all very much.
Thank you, Nicholas. Once again, lots of questions. For those participants, whilst listening to our distinguished speakers presenting and looking at the participants list, you will see that the co-founder of Independent Mediators are also here. Mr. Michel Kalipetis, QC. My apologies for pronouncing your first name differently. Okay, I am certain that this won't mind he joining us when there are questions being raised to the panels. So Michel, you're more than welcome to chip in, so to speak, to answering any questions. Now, but obviously before the question time, we do have questions, okay. I believe that we should have the drill of letting me moderate a little bit, 5 minutes maybe, and leaving the audience to ask questions. Okay. Now, being a moderator, I do have the privilege to ask the first question, to be honest. Now, we have the civil law and the common law. Sorry, we have the civil law and the common law mediators. My apologies. I don't know why my speakers is on mute. I don't know whether you have heard me talking about Michelle chipping in on answering questions. Now, as a moderator, I'm going to ask this question first before I put it to the audience, because I see that there are questions coming in. Now, the reason why I would ask this question is Hong Kong seems to be going the other way. Then how can civil law jurisdictions shift the balance from court-ordered mediations to ad hoc mediations outside the court systems? Now, in Hong Kong, I mean, just by way of background, next week it is moving the reverse, where the district court will order the masters of the courts to be mediators. So it will be court-appointed mediators, not only court-appointed mediators, but court-appointed their own people as mediators. Now, in Hong Kong, this is more like the reverse. So, in the civil law jurisdictions, the shift from balance of court-ordered mediations to ad hoc mediations outside the court system. How can civil or law jurisdictions do that? Maybe Birgit or Claude can answer that.
Well, I would be happy to ask the question, not to answer it, because really this is my concern. I would like to double my rates and generate more money by doing more ad hoc mediation than court-ordered. What is strange is that I have the same lawyers coming to my mediation, and I keep telling them, why do you wait for the court to order a mediation? Why don't you suggest to your client spontaneously to start a mediation before the proceeding? And their answer is that the clients feel more comfortable going to court, probably because they ignore what mediation is about and what Nicholas has explained very thoroughly for his past experience over the past 35 years. I'm afraid it might take that much in France, in which case I won't see the result of it.
Answering now on my side in Switzerland, I mean, as I said, we don't have court-ordered mediations, but only for the criminal justice for the minors. And frankly, I don't think we want to get there because of all the reasons which have been mentioned. Now, to answer your question, I mean, how do we enhance ad hoc mediations, conventional mediations? I think part of the discussion has to do with lawyers, as Claude just said. And I think there is a real education to be made to lawyers, with lawyers, to understand that this is part of a market. It's part of a market, and it's really part of a market where if they don't take it now, it's going to be someone else taking it. We see also the competition between Asia and Europe. We start seeing that there is a lot of competition with respect to the places where people want to try to find an amicable resolution system. So, to my point of view, we need to educate lawyers, we need to educate the community, we need to educate the clients and so on, in order to tell them not only that it's a good system, but that they are part of the system. And this is one of the purposes, at least in Switzerland, of educating lawyers and getting there, because we are going to have less and less court proceedings at some point in time also, because people are going to be fed up with the length and the cost of the court proceedings. So I understand what Claude says. On one side, the people want to go to court first to test themselves, and then they go to ad hoc or they go to mediation, not to ad hoc, but to mediation. But we need to find a system where we give them confidence to try it first, because it's going to be less expensive, more rapid, and so on and so forth.
Thank you, Claude and Birgit. Now, I don't want to put Jonathan, Nicholas, and Michelle on the stand, so to speak, because, as I said, the Hong Kong is introducing what we call the case settlement conference, as compared to the rather historic the case management conference in court proceedings. So this is a new thing we call the CSC. And if I may ask this question, what do you think of a jurisdiction like Hong Kong introducing such court-appointed mediators, where the mediators are in fact judges or masters as in the system? Anyone? Jonathan, Nicholas?
I'm happy to go first. I'm happy to go first on that. I'm sure Nicholas and Michelle will also have views on this. Obviously, the very fact that the courts are encouraging the parties to try mediation rather than go to trial is something that I support. I think I have two concerns about this. One is that however much judges don't think or how much judges think they are good mediators, my experience over a quite long period of time is that there is a somewhat different mindset between someone who's used to determining issues and making findings of fact and finding a result which prefers one party over another, from a mediator who I think very often is trained to be and is more neutral. And in a number of mediations I can think of, the result that we got to perhaps wouldn't have been a result that a court would have got to. And so there's a mind shift issue that I think one has to think about if judges are going to be the mediators. But I think it's only half an answer. The real answer, and just picking up what Birgit was saying as well, is you've got to get the encouragement of the lawyers for this process. I'm still doing plenty of mediations where the clients come in and say, I don't know why I'm here. I'm only here because my lawyers told me I've had to come to this, but I just want to go to court. And that doesn't stop us from getting to a settlement, but it's the lawyers that have taken the clients in somewhat unwillingly at times. And so I think whilst this may well be a good development, it doesn't necessarily address what I think is the fundamental point of educating the lawyers.
May I add to that, Ronald?
Yes.
I would add that I think the skills of a mediator are very particular. If anything, they are a maverick set of skills. They're very, very hard to describe. I can remember during the early days of training that we found it virtually impossible to write down what it was we were looking for, but we recognized it immediately we saw it. And those skills often came from unexpected directions. And they didn't come from expected directions. And generally, Jonathan's point about judges and judicial officers is a good one. The history of mediation in England has been very much one of stepping away from an evaluative, merits-based approach, seeking to reduce the involvement of the lawyers to allow the parties far more scope and space to put their own case. My experience I once co-mediated with an eminent judge who, when the opening session got to the conclusion, he leant forward and said, well, in my judgment, and handed down a brilliant extempore judgment on the issues. And there was stunned silence at the end. And that was his natural instinct, because it was his area of the law, and he probably was absolutely right. But it was death to the mediation process. I'll tell you later what I did. That's not germane. I am noticing, Donald, there's some fabulous questions coming up on the chat, aren't there?
Yes, that's right. So may I just skip Jodie's question? Okay, and my apologies, Jodie. Those are the questions I want to ask as well. But let's go to the first question. What has been the experience in the jurisdictions of the speakers with mediation advocacies? How has it progressed? So shall we start with, to everyone here, to start with Claude, Birgit, and the UK friends?
I'll be happy to just give an input. So as I said, mediation advocacy has really changed in the last more than 12 years, I would say, when we started bringing that into the educational system of lawyers, meaning that being a mediator is not being a mediator's advocate or mediation advocate. It's not because you're a good advocate that you're a good mediation advocate. So you really have to understand those skills. And it's not because you're a good mediator that you are necessarily a good doing a good mediation advocacy. So it really means something a bit different every time, and we need to address that and to give it a credit, meaning we need to recognize that, and maybe we should increase also the knowledge in the lawyers community that this is also part of the what I call the market, meaning the lawyers have to market themselves, and they have to market themselves as being able to do lawyers or mediation advocacy in their practice, because I think that clients are looking for that too. And I have been practicing more and more, as you know, just coming into a dispute, being asked to call in to come in by lawyers who are going to stay the lawyers of the parties, who are going to stay in the process and so on, but just helping them to set up the mediation and to set up what they are going to do and what they're going to say in the mediation, and prepare for that, because preparation is, of course, very important. Thank you.
Ronald, could I add something?
Yes, Nick.
I have seen a total change in styles of mediation advocacy over the period of time. It was very traditional in the early mediations that lawyers would address me almost as if I was an arbitrator. Now, most lawyers spot that the less they say, the better. One thing that emerges very clearly from mediation is if after the joint session you go to the parties separately and say, so what would you say happened there? What's your memory of that joint meeting? What's your reaction to it? They never remember a word the lawyers say. What they do remember is what the other party said. They remember whether the other party was looking at them when they spoke. They remember vividly whether the other party appeared to listen to them, and they have an acute sensitivity to whether or not the other party is actually there to settle with them. But they discount almost 100% everything they hear the lawyers say. And as a former lawyer, assuming everything I said was of value, was part of my raison d'etre. And now I discover that no one actually listens. And most lawyers have got that message, thankfully, and let their clients speak.
Okay. So thank you. Now we move on to the next question. Maybe Jonathan, Michelle, and Claude can have your thoughts on this. Should we go for compulsory mediation, the million-dollar question, or just remain at highly encouraging it? Pros and cons. I mean, I spent over 10 years in US firms doing US cases as well. It's all compulsory mediation. So I'd like to hear from the experts here. Michelle, Jonathan, Claude?
Well, perhaps I can have, perhaps I might just say one word. As you would have seen, Ronald, in America, it's become almost a tick box. And I've seen mediations, court-ordered, compulsory. The parties sit down. Are we going to settle today? No, that's it. Let's get on with the trial. And I think the danger with compulsory mediation is it does lend support to the argument that you're simply forcing parties to go through a process of court procedure rather than a process of mediating to try and resolve a dispute. And so I'm always been against compulsory mediation. And I think there hasn't actually been any jurisdiction where it's been proved to have a greater success rate than voluntary.
Thank you, Michelle.
I would support
yes,
that,
Jonathan.
Ronald. I agree with Michelle. I think one of the tools that the mediator values is the fact that the parties have come there voluntarily with a view to trying to settle the dispute. No one's forced them to come to mediation. And that's something one can use, because you can then talk to them about the merits of settlement as opposed to the potential downsides of carrying on with the litigation. And I think it would be a retrograde if mediation simply became incorporated into the court process. I very often use the analogy of being able to step aside from the court process in mediation, that because of the confidential nature, the informal nature of the mediation, the fact that the mediator isn't a judge, I try in many ways to stress the fact that we're not in court, that we can strip away all the legal language and get back to what the dispute is all about and try and understand what the problem was and how we might resolve it. And I'd be concerned that if the clients perceived my role and the whole mediation role as part of what they had to go through to get before a judge to have a trial, some of that argument would be weakened.
I fully support what Michelle and Jonathan just said, and to show the practical aspect, the first thing I do in a joint session is to explain the parties what court ordered mean, because I'm not sure what their lawyers have explained to them, and I insist on the consensuality of the meeting.
Thank you. Now I see that my friend Menseng, Mr. Young, has asked a question, but before I go on to that question, I want to loop back down to Jody's question, because it relates to compulsory mediation. I mean, in Hong Kong, there's no compulsory mediation, but if you don't do it, okay, there will be cost consequences. Now, so leading up to the compulsory mediation question, Jody has this question, and I have this experience as well. In Hong Kong, it is often seen that parties and their lawyers coming to mediation just to fulfill the court's requirement under the practice directions. Now, do other jurisdictions have similar experience? Because in Hong Kong, we don't have compulsory mediations. And lawyers still comes in and say, okay, let's go for the drill. Let's have a 3 hours mediation and then fill in the certificates and we'll give it to the judge and then we'll go to courts. Okay, so what does the other jurisdictions, do you have the same experience in France, in Switzerland, in UK as well? Anyway.
I say something about the UK experience. We did have a very short period of compulsory mediation. Back in the mid-1990s, the Commercial Court, which handles all international trade and commerce litigation, decided to institute a practice direction that they would not allow a case to be set down for trial until mediation had been explored and exhausted. And they ran that experiment for 2 years. There's no researched evidence into exactly what happened, except anecdotal evidence that the court remembers ordering something approaching 200 cases over 2 years to go and try mediation, and only 3 are said to have come back for trial. And no one really knows what happens to the others. But what was interesting was that I remember mediating one of the very first ones to be ordered into mediation. The parties turned up and they were furious at the waste of time and the waste of money. And why should they have to do this? They were ready for trial. And I said to them, I entirely understand. It's a dreadful thing for you to be forced to do this. But seeing as you've come all the way, why don't we give it till sort of coffee time and just have a bit of a chat? And it had settled by lunchtime, and the defendant bought the claimant and the rest of us lunch. They were so pleased with the outcome. So my answer to compulsory mediation is that people very, very quickly discovered the benefits of mediation. They didn't need to have, we haven't needed to have compulsory mediation in the UK since. We've got the cost sanctions, and the process has proved itself as effective.
Maybe let me just add something to, in Switzerland, we don't have compulsory mediation, but we still have compulsory conciliation. And I was a conciliation judge for 12 years. And I tell you, I think each of the cases I took were taken seriously, meaning that if you take the time, as Nicholas just said, I mean, 3 hours mediation is great. You have the people at the table. What is very, very difficult is to bring the people at the table. But once they're there, why don't we try? And we usually in a couple of hours, we can achieve great results. Also in the change of mentalities. So bringing them at the table, having them there is already an achievement. So I would not be completely against it. And I would see that, as usual, as an opportunity rather than a threat.
Ronald, may I add one thing?
Yes. Yes.
14 years ago, one of our colleagues in Mediators and I, Bill Marsh and I, were asked by the previous Chief Justice to come and train all the lawyers and judges in Hong Kong about mediation. So I think, bearing in mind where we're speaking from, or you're speaking from, can I say, without wishing to flatter, there isn't a set of judges in any jurisdiction that I know that know more about mediation than anyone else. And you can see that in some of the judgments where they have preserved mediation confidentiality. And I think there is an interesting development also in Singapore, where I trained some judges there, that in insolvency matters, they are setting up a regime where before the insolvency gets any further down the path of litigation, there's a special mediation with a judge who is a trained mediator and an insolvency practitioner. And the sole purpose is to see whether the insolvency can be worked out between all the creditors and debtors without lawyers involved. Now, that sort of compulsory mediation can only benefit the clients when it's for a specific purpose. And I think in Hong Kong, the Chief Justice has the same idea. And so I wouldn't wish to write off all the judges, particularly as there's still some that I trained, because they do know what mediation is about. But having said that, the real difficulty with having judges as mediators is not so much the judges as the parties, because as all experienced mediators know, the essential element of settlement are the things that aren't concerned with the litigation, the private needs and wishes of the parties, which they tell the mediator, usually privately. And I think parties will be reluctant to tell somebody whom they see as an official position, who will subsequently be giving a judgment if they don't settle. As representing that system, there will be a nervousness about betraying their weaknesses, their desires, their needs, and their wishes, which are the essential elements of any mediation settlement.
Thank you, Michelle. Now, next time, Jody, you can invite some Australians and American speakers there. I'm certain that we need 2 hours on this issue. And for those who are interested in the new district court rules, which will soon be in the High Court rules as well, the announcement is actually on the 5th of November in the morning, 9 o'clock in Hong Kong. So you can log into the Hong Kong Legal Week and register if you are still up that late European times. Now, I believe the time is up. Now, should I go for one more questions of Mr. Young before we knock off? He's asking how often you may use evaluative approach or model in mediating cases in your jurisdiction. Any particular concerns you may pay in adopting that approach? So, anyone?
This is one of these distinctions that's drawn in mediation, which I don't think in practice has any real meaning. You don't conduct an evaluative mediation as a whole entity, as opposed to, say, a facilitative mediation at all. You don't the process is far more subtle and nuanced than that. I think the general model in England is that we would always start in a purely facilitative style and see where it goes and let it run as far as it will go. The evaluative approach, or certainly a more, not assertive, a more interventionist approach may well not be needed at all, but there are times in difficult matters or where parties get to loggerheads, and where it will not, almost you get to deadlock, where one needs to depart from that and become more interventionist. So it's always a blended approach. I think a purely evaluative approach from the start would be inimical to the entire mediation process. So I'm not aware of ever having conducted an evaluative mediation, and I don't know anyone who does. I do know people who perhaps become a little evaluative towards the end of it when it's needed, but only then.
Can I just add just perhaps a slightly different approach? I think it's a bit like a bell curve, that there are certain mediations where a purely facilitative approach is required. Quite a lot of the mediations I do, they wanted an element of evaluation. They want me to be speaking and testing the cases of each side. And that's my practice. But what I find is that those very, perhaps cases where there's been a lot of money and a lot of lawyering involved, the last thing they want is another lawyer as a mediator to be doing lawyering. They want him to be purely facilitative. And so it's curious that at both ends, the very simple cases where perhaps a lot of emotions are involved, and the very complicated cases where there's a lot of lawyers involved, one is much less evaluative than maybe in the middle. But I also agree with Nicholas that it's always a blend. There's not one or the other, and you've just got to see what the dispute is about and what the parties want.
Richard, I see that you have unmuted your mic. Any comments?
I mean, if I can just give my 5 cents. I think, and I absolutely agree with Jonathan and Nicholas. The question is, what are the parties' expectations? So, from my point of view, and this is something we have to address at the very start of the mediation with the lawyers and with the parties, what kind of approach do you want me to have? Do you want me at some point in time to get to something which could be more evaluative? And if so, who is going to tell me when? Because otherwise they're going to wait for me to being that, or I am going to wait for them to give me the signal. So it's always the same. I mean, at some point in time you have to manage expectations, but I don't see any issue at some point in time to become evaluative if this is what is requested, but I would certainly never start with that.
Any comments from you, Claude, from France?
Well, no comment. I agree with what has been said, and I will put it differently. One thing that we don't do, mediators, we don't put on autopilot when we start the mediation. Not one is the same as the other. And Nicholas put it very rightly, it is a blend. And it is a blend that unfolds as it goes.
Thank you very much. According to my clock, it's 8 o'clock at night, 8:38 to be exact. We have overrun by 8 minutes, and I see that we have not lost any audience. Interesting. So with that, I think we can close the panel, and thank you, Jody, and the organizers in organizing this Capsule Four. It is definitely interesting, and obviously you can all see the comments. There's still comments coming in from Israel and from Scotland, I believe. So with that, thank you very much. It's very interesting to me as well as a practitioner. And to end that, I think Beatrice and Renee Charles said that excellent. Thank you very much. So, and thank you the audience as well. Thank you.
Thank you very much.
Thank you.
Thank you,
Thank you,
Bye-bye.
everyone. Been
you.
great
Thank
pleasure.
you, everybody. Bye-bye
Thank
then.
you.
Claude, thank you. Birgit, thank
Yep.
you.
Bye-bye.
Jonathan and Nicholas, thank you both very much indeed.
Yes, very nice.
Thank
talking to
you.
all of you.
Thank you, Ronald, for moderating so wonderfully.
Ronald, very good job, moderating. Thank you.
Thank you.
And
very much.
Jody, bless you. Thanks for that.
Thank you,
Yes.
Nicholas, Jonathan, Birgit,
Yes.
Claude, and Michelle.
Yes.
Thank you
And
very
all
much.
the best for you next week in Hong Kong then.
Yes.
Yes. Next week is the Hong Kong Legal Week.
Exactly.
Thank you. Cheers.
Very
Okay,
good.
bye-bye.
Lots
Thank
of
you
fun.
for inviting
Bye.
us.
Thank
you.
Ciao. Bye.
Some very nice feedback, Jody. Looking at the chat column.
Yeah, I think we still have a lot of good questions. We don't have enough time to answer those questions.
I don't know if you saw, a lady asked me what the end of the story was about the judge giving judgment in a mediation. So I
Did you
tried to do a quick answer.
Yeah, I
get
thought
your commission from Starbucks?
No, I mean, he realized the moment he stopped, he realized he'd done something wrong. So I just said to go off to the coffee shop, do not come back for half an hour. And I said to each party, let's just pretend he didn't say that. And they went with the pretense. We pretended he said nothing. Anyway, Michelle's on the phone. I better answer him because he's the boss. Hi, Michelle.
Well done.
Thank you.
Is Jonathan still on the line with you?
No, Jonathan has left. I'm talking with Claude and Jody, who's looking particularly glamorous today.
She always does.
Doesn't she
Everything
just?
is well done. I'm very
Thanks.
grateful indeed.
Thank you.
We'll see you
Bye.
later. Take care. Bye now.
Dear colleagues, this is Dwight Golan. You do have 26 of us with you. Just bearing that in mind.
Well, Dwight, hello. There's a name I recognize.
Hi, Dwight. It's Jody.
Well, how did it come across? I mean, the problem always with the English is that we have that we treat everything lightheartedly and not as it never sound as though we're being very serious about it. It's very much the English way, but they. I thought there's some terrific questions coming up on the chat room.
Yeah.
Well, hi, Dwight. Good night, Jody. Good afternoon, Nicholas. I'm leaving
Okay.
you.
Me
You are,
too.
Claude. Good to
Bye-bye,
see you.
everybody.
Bye then.
Bye-bye,
Birgit.
Birgit.
Lovely to hear you.
Bye, Birgit.
Right, I must go as well. Bye then.
Bye.
Goodbye.
Thank you. Thank you so much.